Hello, everyone. My name is Fiso Bernard Nomalo. I am the president of the Oxford Law Black Alumni Network at the University of Oxford. And I'm absolutely thrilled and delighted to be in conversation with Dr. Courtney Griffiths, QC. He is a distinguished barrister who currently practices at 25 Bedford Row. And he is a criminal barrister with over 40 years of experience at the bar. He has far too many cases that he's appeared in, which are high profile. And if I were to list them all, we would be here for the whole day, which is something that he cannot afford to do, nor can I. But just to mention a few, he represented Charles Taylor in his trial concerning in his trial against war crimes, for war crimes. And he also represented the accused in the Harrods bombings and the Brighton bombings. And as of recent, he was representing the Judge President of the High Court in South Africa, Judge President Hlophe. And if you have any time, please do spend a few seconds or a few minutes listening to his opening statement in the Charles Taylor trial. It's on YouTube, and he quotes, if I'm not mistaken, Bob Marley. It is an outstanding opening statement, and you would benefit a lot. With that said, Dr. Griffiths, welcome, and thank you for joining us today.
My pleasure.
So just to begin, can you take us through your journey and growing up as a immigrant in the UK and how life was back then?
Well, I was born in Kingston, Jamaica, the second youngest of a family of 8 boys and 1 girl. And my father was a carpenter. He was involved in construction. And so when I was 10 weeks old, my father left Jamaica, arrived in the UK, initially in London, then moved to Coventry. The reason being, there was a lot of construction work to be done in Coventry because it had been flattened by German bombers during the Second World War. And so, for example, my father helped to rebuild the medieval cathedral, which had been flattened by the Germans. On my arrival, I was 5 years old. And all of us were growing up in a 3-bedroom house in Coventry, in one of the poorer areas in Coventry. But fortunately, because I'd been educated before leaving Jamaica, I was placed 1 year ahead of my age group in primary school. I managed to pass my 11+ exam, which was a route to the better schools in Coventry available during that time. And the school I attended was called Bab Lake Grammar School. It was actually built and begun in 1344, so several centuries before. And eventually, I was the only Black child from an African Caribbean background in the school of about 1,000 boys. And there was one other non-white student who was from India. He's currently a doctor in Vancouver. But in any event, I did my A-levels at Bab Lake, did well, and I applied to Oriel College, Oxford to study law. Because at the time, I thought it was a good idea to study law at university.
Okay.
What happened was I was interviewed by a professor at Oriel College. But unfortunately, they decided, not surprising now that I know what Oriel College is, that they didn't think I ought to attend. So fortunately for me, I got a place at the London School of Economics to study law. And to be quite frank, studying law at university, to my mind, is the biggest mistake I've ever made. And I tell you why. Because the 3 years that I spent doing that law degree, the subjects that I studied, such as the law of contract, tort, constitutional law, and so on, I have never used any of it. Since I was called to the bar in 1980, so I've practiced over 40 years. And my skills as a criminal defense barrister were developed on my feet in court over those years. It wasn't what I'd studied at university, because perhaps in a sense, if I'd studied history at university, which was my favorite topic back then, which enables you to follow the development of historical attitudes in law, that is precedent, I would have been better off. I would have been less bored doing the law degree. But, you know, I decided to become a criminal barrister. The reason for that was growing up in the UK in the 1960s and 70s. As we know, the police were extremely racist nationwide. They killed a Nigerian African man and threw him in a river in Leeds, in Yorkshire. When I was like 15, was stopped in the shopping precinct in Coventry, where the police had like a cubicle in the middle, taken into the room and threatened, and I'd done nothing whatsoever. And that happened to me. And as a result, and because of the way in which Black people, particularly young Black males, were being treated back in the day, the reason why I decided to do law was in order to fight the police. And the point is, life practicing law has changed considerably over the years. When I started in 1980, much of the evidence relied upon by the prosecution were admissions allegedly made by the defendant, most of which was manufactured. And also back then, interviews by the police were handwritten by them. As a result, oftentimes, what was recorded as having been said didn't happen whatsoever. As a result, when I began, much of the cross-examination was of police officers, calling them liars, alleging that they'd manufactured aspects of the prosecution case. And in due course, the government recognized what was going on. That's why the Police and Criminal Evidence Act 1984 was introduced. Remember, that's what introduced the recording of the interview. Yeah. And that changed life altogether, along with other things. For example, guidance as how to handle identification parades and the like. None of that was there before. And so times have changed considerably over the years, so that nowadays, criminal trials don't involve a great deal of cross-examination at all. And I say that for this reason. For the last 30 years, I have mostly done, apart from 5.5 years in Holland, defending Charles Taylor, I've spent most of my time in the UK at the Central Criminal Court, the Old Bailey, doing back-to-back murder trials. And the reason why I began on that particular route is because I started doing murder trials when I was quite junior as a barrister. But I started for this reason. Back then, so-called yardis, that is, alleged gangsters from Jamaica, had entered the country, were involved in drug dealing, and also involved in firearms-related cases. Now, most of them, as I still do, spoke patois like a Jamaican. Did you understand me? Did you get
No,
that?
I didn't. Yeah.
They spoke what's called patois, and it's a completely different accent to the
Okay,
English I'm currently speaking. And back then, there weren't many Jamaicans like me practicing at the bar. And as a result, I started doing those cases approached directly by these Jamaicans and was able, in effect, when questioning them, to translate what they were saying to the prosecutor, the judge, and the jury. That's how I began life at that stage, doing these back-to-back murder trials. And the fact of the matter is, the vast majority of the cases I did during that period was defending Black defendants. And that situation at one level is worsened because there are 18 courts at the Old Bailey. And on any given day, I promise you, the majority of the defendants on trial for murder are Black, male, one or two females, and occasionally a working class white defendant, but only occasionally. And what has changed, you see, folks, is this. Remember I mentioned that I used to cross-examine a lot when I started. Now, there's hardly any cross-examination involved. The reason being, as we know, the country is covered with CCTV cameras. As a result, the main evidence in most of these cases now is CCTV. Hardly as many eyewitnesses as there used to be. So the investigation is conducted in this way. Officers come on board and they visit every place which has a CCTV camera. Homes, shops, stores, the local authority, and collect all the CCTV footage, then spend weeks putting together a compilation which shows where the defendants came from, where the deceased came from, what transport they used, what occurred at the scene. And that compilation is then given to the jury so that when they retire, they have a record of what occurred. As a result, what questions can you ask as defense counsel? All you can ask is the police officer, where did you get that part of the compilation from? So what? It's totally irrelevant, because what's relevant is what can be shown on CCTV. So the highlight of the case you're dealing with is calling the defendant to give evidence, to answer, why are you on there? Why did you do that? Why did you come from there via this route to get there? Right? So that's what the defendant has to deal with. And then you make a speech to the jury to explain what's on that compilation and why he's not guilty or suggest that. As a result, the further evidence is the mobile phone, because as you, I'm sure, knows, when you're using the phone, it's using a pattern of your movement can be shown. So that, for example, I'm starting a murder trial on Monday. And again, it's that same evidence which is at the core of it, right? And so you have to be in a position to explain that unchallengeable aspect of the evidence. You've got to explain why that occurred. but you can't really question the reality of what's on the CCTV compilation. It's there. And the jury are going to retire with it and take as long as they want to come to a conclusion as to what it shows. And so you see how the times have changed. It has completely changed. You know, you're lucky if you have to cross-examine someone in any depth nowadays. So times have changed. And also another aspect as to why times have changed is that, you know, legal aid in most of these criminal cases, the defendants are legally aided, has been reduced quite considerably. So that at one level, law students now have to think about what area of law they want to practice in. Yes, being a criminal barrister or solicitor looks exciting and interesting. In reality, it's no longer is. And furthermore, you're not going to get paid that much. So you need to be thinking about from now, what area will be worthwhile to practice in? How are you going to succeed economically having taken a law degree? And the other thing that I think students need to bear in mind, although I appreciate I'm speaking to people at Oxford University, they have an advantage. Because if you come to the bar, the predominant university from which the barristers come are Oxford and Cambridge. And most of those who are in the commercial areas where you can make money come from Oxford and Cambridge. And thereafter, University College London, LSE where I went, and King's College London. And one of the reasons for that is those colleges are very close to the Inns of Court, the Royal Courts of Justice, where the Court of Appeal is, and the Old Bailey, where the main criminal terrorist murder trials are tried. And so while still at university, they can make contact with barristers and understand how the profession works internally and the route they need to take if they want to succeed. The other problem with the bar, which I think they ought to be aware of, is this. Remember, you're paying for the degree now for 3 years. You're paying for your accommodation during that period. And then in order to qualify as a barrister, you've got to take the bar exam thereafter, which is a year doing a further course. Now, that year is very expensive. In London, it's going to cost you between 15 and about £18,000 to do the course for that year. And remember, you're still paying for your accommodation. And the thing is, each year, about 1,500 students graduate from the bar exam. But the important point which needs to be borne in mind is this. In order to qualify as a barrister, it's not just doing that 1 year course. You've got to get pupillage. Now, the thing is, 1,500 graduates finishing the bar exam each year. Do you know how many pupillages are available each year? Only about 400. So that means that over 1,000 of those who do the course are not going to be able to get pupillage immediately they're finished. And they can only be making those applications for 5 years. Then the bar examination qualification goes, and you've got to do the bar exam again. And so you can see why I am suggesting that people have to start thinking about how are they going to get into the bar from when they're doing the law degree, making contact with barristers, making the travel from Oxford or Cambridge to the Inns Court, right? Making connections with practicing barristers and so on. So they fully understand what is required in order to cross the barrier of the absence of pupillage, what I need to do. Because it's not just about getting the law degree. It's not just about doing the bar exam. It's about gaining other experience outside of that, which demonstrates to your examiners when you're applying for pupillage that you've got lots of experience. You've got lots of gifts to bring with you as an incoming pupil. And you have the prospect, because of the way in which you're expressing yourself, which you will learn from going to court on top of the degree. And that's what you require. So that's the overall picture law students need to bear in mind, that it's not straightforward. It's not just about getting the first degree and getting a high grade. It's about gaining other experience as well and appreciating what it's going to cost you to make it through that route. And we also have to bear in mind, and Sfisa, I mention this because you see my color, I'm black, all right?
Yeah, yeah.
And the bottom line is, the bar in particular is still at one level very racist. There's very little diversity. And most of the chambers in the commercial areas where lots of money is made are all white. That's a fact. And there's still quite a lot of quite white chambers all over the country. And so, you know, that has to be borne in mind. I've got to be thinking about, how do I create a personality which will lead those from whom I'm seeking pupillage to think, this guy could be good, this woman could be good. And yes, it's gradually developing, but not as quickly as a lot of people would like to make out. It's not.
Yeah, yeah.
Racism is still a major factor in entering the law. And yes, you have quite a few doing like immigration law, some family law, some, and quite more now, a lot of criminal work. But, you know, the other areas where real money is to be made, not yet. Not yet, very little impact yet. Very little thought given to diversity yet in certain places. And, you know, bear in mind, the High Court judge, those judges are mostly white. I think they've only had about 2 non-white ones.
Mm.
You know, only about 2 in all these years. One of them was an African, Linda Dobbs. She's not in your country, South Africa.
South Africa, yeah.
Cape Town. Okay.
So just to touch on, so you've said quite a lot of important stuff, and I'm just gonna try and maybe just focus on a few. One of them was, you said that you haven't used some of the things that you learned in undergraduate.
Say that again.
That there are certain things that you haven't learned, that you haven't used ever since you left law school. So there's certain courses that you haven't really done and that you learned on your feet. So do you think that there's something inherently problematic about legal training and legal education? Is it limiting? Is it geared more towards perhaps creating academics that don't really have the sort of skill set, so to speak, to be good barristers or solicitors?
That's not quite the point that I'm making.
Okay.
Many people, you see, Sfisa, are attracted to the bar because barristers stand up in court, make legal arguments where they're arguing with the judge, address the jury, or cross-examine witnesses. That's not taught when you take a law degree. That you learn when you get on your feet in court, right, and have to get into that advocacy. That's not taught at university, which is why, you remember me mentioning the need to be going into the Inns of Court, the need to be going into the courts so that you see how people are performing. Because it's about that aspect of it is about performing, not what you've learned. It's not what you've studied. It's what you've got to pick up for yourself, through which you can advertise what your abilities are in that sense. And you're not going to just pick it up from doing the law degree, you know. Now, different things apply in other places. For example, if you want to go into a commercial firm, say a solicitor's firm in the city, you need that legal concentration, because most of that work is on paper. Well, it was when I was starting, but now it's on the computer and I'm not that good at it, right? And so you need to have the ability to be on the computer, access the law on your computer from Westlaw or from one of the other internet legal opportunities, right? And, you know, putting together your written pleadings and stuff like that, okay? Yes, advocacy isn't really that important if that's what you want to do, right? And the advocacy style, when you're doing that kind of commercial civil work, is slightly different, because when you're doing it in crime, at one level it's more emotional, because you're in front of a jury, right? You're in front of a public gallery where the families and friends are watching, all right? It's not really, that's not really the case when you're doing civil work. It's about legal argument, being able to spot what the legal problems are and how they should be approached by the judge, not a jury, all right? And so it's a different style. And so students need to become aware of that as soon as possible, because that will assist them in deciding what it is they want to do. Because when you enter the law degree, you might have certain expectation about what you'd like to do and what you'd want to do. That's not all of it. You need to know precisely what is required. That's why it's not just about going to university and being in the library. It's about taking time out, which is available, and sitting in court to see what's going on and what you require in addition to having the textbooks.
Perfect. I completely understand that. So you also mentioned how, you know, back in the 70s, 80s, you know, there was a lot of issues with the criminal justice system and how it treated Black men specifically, and Black people generally. I was curious, do you think there's been much of a change? So outside of the more digitalization per se of, you know, now having cameras during, well, in every corner of the city, do you think that there's something that has changed about policing of Black people, the treatment of Black people within hearings? Because as you said that, you know, some of the judges are predominantly, well, almost exclusively white. Has there been substantive change in how Black people are treated by the justice system from then to now?
I'm glad you used the word substantive. There has been some change, but it's minute. Stop and search, for example, for members of the public is still more predominantly associated with non-white people. In certain areas, ghetto areas, in effect, council estates, right? And the style of policing in those areas is completely different than in the middle class, rural areas. Completely different. So that there is still racism involved in the conduct of the criminal justice system. And I'll be blunt, although it's political, and say this government, the contemporary conservative government, in that sense, is still very racist. They're not interested in changing that.
Yeah.
They see it as part and parcel of the control they require in certain communities. So it's still there. And you notice what was said by the Mayor of London recently about the Commissioner of Police for the Metropolitan Police, the biggest police force in the country, and why she's left. Because there was no attempt by her, to change that attitude.
Yeah.
None whatsoever.
Yeah. I mean, also last year, didn't they commission that report that found that there was no institutional racism in the United Kingdom, and that the United Kingdom is a beacon really of how to be a non-racial society, which is quite problematic because of the definitions that they used. But that's besides the point. So also there's been some debates speaking about, because I think you mentioned juries and having to know how to argue in front of juries versus when you're presenting perhaps arguments towards the judge. There's been debate about the use of juries, that are those actually good things to have, or are they bad things to have? And I was curious to get your viewpoint on that. Do you think juries are useful, or are they bad? And I think one of the main critiques that has been put forward is that juries don't provide, or they don't write reasons. They don't write reasons. They don't provide judgments. They just, come back with a conviction. Is that something that is problematic and should be changed, or is it, not really as big of a deal as people make it out to be?
I don't think we ought to stop using juries. That has been part of life and the conduct of criminal justice for centuries in this country. And, the British Empire transferred that thought around its colonies worldwide. And it still exists in many parts of the Caribbean, and to an extent in some parts of Africa. All right, so I'd like to have juries retained, because quite frankly, being a judge at one level is quite political.
Okay.
Because a certain expectation comes from the government as to how you, a judge, should behave. Independent, objective, unemotional. What in reality does that say? What it says in reality is experiences you may have had as an individual is totally irrelevant. That's not your role as a judge. So the only people still in the criminal justice system who can employ and deploy that kind of experience is the jury. That's why I want them retained. Because having that presence in the courtroom, able to look at other aspects of the case, other thoughts which might be relevant, which have not been brought forward in the evidence, right? I think is an important factor. Because remember, you're dealing here with, for the most part, working class defendants coming from a particular kind of background. And evidentially it might be unimportant. But when you're considering a particular emotion which might have triggered something, you're better placed to do that, given where you come from. You don't need to be a lawyer, qualified and able to understand and express the law to be able to evaluate that.
Mm.
And that's why I think juries are important.
So would you not be comfortable per se with the idea of perhaps getting a commissioner of who just sits there as an assessor of some sort, and they take over the role of the jury, but they would predominantly be perhaps required to provide some form of reason as to why that decision is? Or do you think that juries, as they currently stand, are fine, and maybe there might be issues with perhaps the composition of juries, but overall they are a perfectly legitimate way to sort of make findings of fact?
Given the point you make, I think mention ought to be made of the fact that currently there's certain aspects of the jury composition which is somewhat concerning. One of the reasons I say that, right, Sifidioso, just by way of example, a lot of Black kids now are excused from school before they've taken their GCSEs and A-levels, right? And sometimes for ridiculous reasons. So as a result, they're kicked out of school, can't get an apprenticeship, a job, or anything like that. So many of them, frankly, get involved in gang activities, selling drugs. And quite stupidly, some of them, by way of example, will take drugs out of London and sell them in rural areas. Okay? Now imagine if they get arrested in one of those rural areas and the jury is selected, how many Black people live out in the rural areas? So how many of them are going to qualify to go on a jury? And so what do you think the attitude would be towards a Black defendant who doesn't populate the area, but is out there making money, and whose activities might have resulted in other criminal activities? If such an individual appears in front of all-white jury, what do you think the outcome is going to be?
They're probably going to be found guilty. Yeah,
exactly. That's pretty obvious. And you see, I raise it in part for this reason. For a short while, beginning in the 70s, it was argued in court that where you have Black defendants on trial, you should have a multiracial jury. Court of Appeal said, no, you've got no right to that. Okay? So as a result, now, you've got no choice to make. When I started doing criminal work, you could challenge jurors and play a role in the composition of the jury. Not now. Only the judge can do it. And so as a result, let's forget about diversity when it comes to the composition of the jury. We have no right to try and insist on that in law anymore. Times have changed.
That is very heavy. Okay, perhaps just to maybe, we will get back to some of these points a little bit later, but just, I'm very excited to get into some of the cases that you've dealt with. And I think the most obvious one would be the Charles Taylor case. Could you take us through that? So for those who don't know, perhaps maybe just some background and how you got involved, and also your own trial within a trial, so to speak, if you can speak about that.
Okay, all right. The Taylor trial is one of the most challenging experiences I've had at the bar, for a number of reasons. Number one, there's a certain politics in the background to that trial, which most people don't understand. One of the main pressures asking for Taylor to be arrested and taken out of Liberia came from the United States of America, Tony Blair here in the UK, France, and a lot of the Norwegian countries. They funded the Special Court for Sierra Leone. That's where the money came from, okay? And I've just discovered quite recently that the prosecution paid certain individuals to obtain the witnesses called. And those witnesses were in effect given money to give the evidence against Taylor. Despite the technology available during the Civil War in Sierra Leone, which was the main aspect of the case, there was no satellite evidence, no telephone evidence, no technical unchallengeable evidence like that called at all. We're talking about a case based on 90 odd witnesses shipped from Sierra Leone into Holland and held in effect in a concentration camp whilst they were giving evidence, held in a prison, a former fire station with barbed wire and guards so they couldn't come out, except in a van to go directly to court, okay? And the prosecution were able to rely upon that. And remember, we had no jury.
Yeah.
We had a judge from Uganda. We had a judge from, if I remember rightly, the Philippines, and a judge from Northern Ireland. Okay. And it took them quite a while, and one from Senegal. And one of the major things that upset me was this. The judge from Senegal was there in case something from the other, some health or other reason meant that one of the others had to go, then he would take over. But he was there throughout the whole trial, which lasted more than 5 years. And what happened was, 3 of the judges, 2 white, 1 Ugandan, came back and gave the verdict of guilt. The Senegalese judge started to give a judgment of acquittal. And the president of that court told the court clerk, switch off the camera, switch off the microphone, and pull the blind down on the public gallery so they can't see or hear what he's saying. Why? How many cases have taken place where a judge gives a dissenting judgment, which is recorded? Yet here, such was the politics involved that they decided the world must not hear what this African judge is saying about this case. Yes, the decision should only be known about what those who found him guilty said. I find that very disconcerting. I cannot understand, as a lawyer's practice for this time. Sure, if you don't like what he's saying and you disagree with him, let him say what he has to say, right? Because look, we're the majority.
Yeah.
So why are you hiding it? Why are you hiding it? And you know, funnily enough, one of the court staff who knew what was going on in the background, whilst that was being done, ran over the court towards me and whispered in my ear, Mr. Griffiths, that printed before it disappears. That's the only way. And that judge from Senegal has since given, I didn't an article in an African magazine where he said sound precisely what was going on in the background throughout this case. And the funny thing is a deceased note, Fiso. I went to see Taylor in July 2007 when he decided to get a different legal team and I was brought in, right? And I went to see him in the prison he was at in Den Haag. And I said to him, Mr. Taylor, I'm more than happy to represent you, given the nature of this case and what I consider to be its historical significance. But I'm telling you from now, you're going to get found guilty because of the politics behind this case. That's the deal. I told him. And he said, yes, Mr. Griffiths, I know that to be the case. I know what the politics are in the background. And you see, when you bear in mind other aspects of the case, which have never been made public, by way of example, Johnson Sirleaf, who, as you named, became the president, the first female president in Africa.
Yeah.
Before the civil war broke out in Liberia, she worked for the World Bank. So she was known in the States and in Europe. Yet, Taylor trained his troops in Libya in a camp financed by Gaddafi, which also trained the IRA and other alleged terrorists from around the world. And guess what? Who was assisting Taylor at that time? Johnson Sirleaf. So that when the Civil War kicked off, she was in the background assisting with raising the necessary finance. But given her background, having worked in Washington and having contacts in Europe, why do you think she became president? And funnily enough, the Liberians decided to inquire into who was responsible for the Civil War. Guess who one of the persons was as their name? Johnson Sirleaf. So you can understand why she wasn't charged alongside Taylor as a co-defendant with the war crimes. Because there were Western interests there in her becoming the president. You remember where I started? The politics in the background.
Yeah.
That's where I started. And you can see why, although Liberian people knew what had gone on, investigated it, came to conclusions as to who was responsible. And it wasn't just limited to Taylor. And yet he's the only one trying. Another aspect of it which needs to be borne in mind globally is this. Yes, I defended Taylor. At the center of the allegation against him was that he was almost wholly responsible for the civil war in neighboring Sierra Leone. Terrible things happened in Liberia as well during their civil war, in terms of, people being amputated in public, people being killed, and so on. That happened in Liberia as well. Why wasn't Taylor put on trial for that? Why were all the others responsible for what occurred in Liberia? Why weren't they put on trial for that? If you can have a court, the Sierra Leonean criminal court, why didn't you have a Liberian criminal court? If you're so concerned in the West and in Europe about what happened during those civil wars in West Africa, why did you have one in Liberia? Particularly, as you remember, Taylor was arrested leaving Nigeria to go into Mali, right? was put in prison, so he's in custody. So what was to stop him from being put on trial for what occurred in Liberia, not just what occurred next door in Sierra Leone? What? Then neighboring countries. If you're so concerned about it, why didn't you look up the whole issue, which led to civil wars in two neighboring countries? And on your account, Taylor was responsible for both. Yeah. So why just put him on trial for what happened in Sierra Leone? There were politics dominating the background, and that politics was in the hands of Western countries. Yeah. Because remember, the other thing is this. It's alleged Taylor had certain bad habits. But remember, Taylor was the first non-military leader in that part of West Africa. All the neighboring countries were run by generals who had taken over. And they didn't like Taylor for that reason, because he could have introduced or supported democracy in their countries. And who do you think might have preferred to deal with military leaders than someone in a Black country who decided to act democratically? Who do you think might have benefited from that? You think Reagan, Bush, Blair might have benefited because of their alliances with those leaders and their desire to keep democracy out of it so they could retain economic control? And so, I learned my lesson from that. Right, I learned my lesson and understood what was the reason for it, why it was created, and why it went ahead in the way it did. And do you know that Taylor's serving that sentence here in the UK, 50 years?
Yes, yes. So I mean, I was shocked at the fact that, because at first I thought it was a international court, international crime court, ICC.
The international court had nothing to do with that. What happened was this. Remember, they built a court in Freetown in Sierra Leone, where all the local Sierra Leonean RUC alleged war criminals were put on trial. And they're serving their sentence in Rwanda. What happened was, Taylor was in prison right next to that court in Freetown. And then the Sierra Leoneans said, we don't want him tried here, because he only lives next door in Sierra Leone. Trying him here might lead to his military supporters in Sierra Leone coming here. So we want him out of here. So what happened was, there was a deal. Blair, the former prime minister, was heavily involved in it. So the Dutch said, all right, look, the ICC has been set up. We've assigned a building to be the court, but we haven't actually started yet. So you can bring him here and try him there in the ICC court. And that's what happened. That's why he was tried in the ICC, right? But the Dutch said, yeah, you can try him in our court, but if you send him to prison, which I guess they knew was going to happen, we don't want him here in prison. At which point, Tony Blair, whose father had worked with one of the oldest, if not the oldest university in Freetown, right? So Blair had certain connections emotionally, having gone over there before in Sierra Leone. So Blair said, all right, try him here in Holland, but if you get found guilty, And he kept quiet about Lisbon, which I know he will be. He can do his sentence in the UK. So that's why he's here.
Mm, mm. And he's effectively going to spend the rest of his life in prison.
Pardon? He didn't
he's effectively, I was saying that effectively he's going to spend the rest of his life in prison. I don't think he's going to get any parole.
That's reality, because he was given that 50-year sentence when he was in his 60s.
Yeah. No. And then I wanted to ask you about, because this is a hearing about civil war within certain countries. Why was Naomi Campbell brought in? That seemed like, that's not a place where you'd mention that particular name. How does she come into the play?
Well, funnily enough, you ought to know this, Fiso. She went down to Joburg as a visitor to President Mandela.
Yeah. So I do know the story, just for those who...
You know the story, right? So she's supposed to have got these blood diamonds from Taylor, right? And why he, having gone down to this party in South Africa, meeting a model, right, would want to give her blood diamonds. What does he gain? What would he gain from that? All the way down in South Africa. It's not as if he was giving it to someone who was selling diamonds in, in London, in Hatton Garden. All right. So what was he going to gain from it? And so no doubt, the underlying allegation was that Taylor was trying to go out with her. That's got to be the obvious thing. Right. So it's total nonsense. And why that was being called, I don't know. And the thing about it as well that you've got to bear in mind, she was called along with the woman who looked after her interests, her agent, right, in the middle of the defense case. Not as part of the prosecution case. They closed their case. We were in the middle of the defense case, and that's when they called it. And the idea, I think it was one level, was distraction. Another level, to raise funds for the trial, because it had been going for so many years and they were running out of money. And they needed to attract money by heightening the profile, which of course Naomi Campbell was going to bring
in. No, I completely understand. So just because we're running out of time, I just want to bring the penultimate question. What happened that ended up getting you in South Africa? What was that all about? Why were you particularly called? So for those who don't know, the case is that there is a judge president in South Africa, John Tlhophe, who studied at Cambridge, very smart, very accomplished Black man, who is accused of trying to influence two constitutional court judges by using a phrase that says "Si Tembelini." And the question was, what does that particular phrase mean? Was he trying to influence them to decide a particular case concerning the president in a particular way, or was he just saying it to say, well, you are the last resort of the country or something of the nature? So that's really the debate. But why was this UKQC called in, really? That's the big question.
All right. Sfisa, you're a Zulu, right? Tlhophe is a Zulu. I was instructed by a man whose surname is Zulu.
Sure.
Right?
Yeah.
Having been going back and forth to South Africa since 2013, last time it was December last year, I've learned a few things. First of all, the remnants of apartheid still exist in South Africa.
Yeah.
And surprisingly, it still affects the way in which the courts and the judiciary are conducted. Cloplay being Zulu, like Zuma, at the base of the allegation made against him of miscarriage is the idea that when offenses were being brought against Zuma, Cloplay stepped in and spoke to two constitutional court judges in order to persuade them to drop the case against Zuma. That's the deal. So at the bottom of the allegation is firstly, he's a Zulu and he tried to assist Zuma. He's Black and thinks he's good because he's the justice president in Western Province, Cape Town, which still behaves as if it's a white-owned province in South Africa, okay? That's where the conflict started. That's where the aggression started. It started from the fact that, as I've said to you, apartheid still exists, particularly economically. And I also notice in the judiciary in South Africa, and I find that very frustrating. I love South Africa. It's a beautiful country, right? And I enjoyed working out there. But that aspect of it has remained in my mind and concerns me, given that, to my mind, it is perhaps the most prominent country in Africa. And should be. Right? But the way that Cloplay was treated, I find quite astonishing. Number one, he's one of the oldest serving judges in South Africa. Number two, he's one of the most experienced of those judges. Number three, he's one of the most intelligent legal authority in the country, right? And there can be no suggestion that he's done anything, to my mind, illegally. And when one bears in mind what happened during the course of these hearings I was involved in, remember, at the center of the allegation is that he tried to use two constitutional court judges, all right, to assist Zuma, right? When we started in the tribunal in September 2013, we started the proceedings. Those two judges refused to attend. The president of the tribunal was making legal arguments as to why they ought to attend. They took the matter to the highest courts in the country, challenging why they were being called and why they should not be giving evidence. Eventually, they turned up last December, and I challenged them. And if these students at Oxford want to learn a bit more about it, that cross-examination by me, and I'm not boasting, can be seen on YouTube because it was done live in front of the population on the TV. And those two judges, in terms of the allegation they were making, in effect withdrew it. In effect withdrew it. I said, that's not the interpretation. And yet, guess what? The tribunal, the president of which was a white man, convicted it, well, felt that the case ought to be brought against him. And it's still going on.
Yeah.
I remember, it started in 2008. We're in 2022 now, and it's still going on, this complaint. Why?
Just in closing, if you could maybe just describe when you retire, whenever that is, when you decide that, well, I'm putting the pen down, I'm taking off my my robe and I'm no longer arguing. Good thing. Do you still wear the wigs? You no longer wear wigs.
No, I still wear a wig.
Oh, so when you put the wig down,
I've got one here if you want me to put it on. Give
no,
me a sec.
it's okay.
Give me a sec. See, first, look, I still got it. And it's 40 years old. Right, but I'm not going to wear it for the rest of my life. And when,
Thank God.
and when I go in my coffin, I'm not wearing it.
But when it's all said and done and you've retired and you've finished, what would you like your legacy to be? What would you want people who are coming up to say about you and say, well, this is how he contributed or how he should be remembered?
Well, I want to do some writing when I retire, and I hope they like my books, because I'll be writing about some of the things that I did uncovered in court, and hopefully the members of the public might learn a bit of the history for Black people in terms of their contact with criminal justice. That's what I prefer.
Okay, thank you so much. I wish we could speak more, but unfortunately we are a little tight on time. But thank you so much for joining us. This was really, really insightful. I am looking forward to joining you in London soon, and visiting the Old Bailey and experiencing a lot of heartache. But thank you so much for joining us. And for those who are watching at home, who will be watching this, thank you so much for joining us and privileging us with your time. Until next time, bye.
No problem whatsoever. Take care.